Wolf-Teiss Soundshot. Insights and analysis from one of the leading law firms in Central, Eastern, and Southeastern Europe.
Welcome to a new episode of the Wolf-Teiss Soundshot. For this episode, our speakers will be discussing the topic of Chinese investments in Europe. Christian Mikosch, partner for our corporate M&A practice and head of the Wolf-Teiss China desk, invited Michael Tso, partner at Chance Bridge and specialist for China outbound investment, to discuss this topic together. They will give a brief overview of Chinese investments in Europe, including risks Chinese investors face. They will also cover the differences in this regard between Chinese state-owned enterprises, private companies, and private equity investors, also touching upon why capital remittance controls matter.
Welcome to our podcast. We've seen a lot of Chinese investments over the last years, and as many of you will know, Wolf-Teiss has a dedicated China desk headed by me, Christian Mikosch, and we have our various colleagues helping us with the China desk, whom you already know. And we have also Chinese language capabilities, and we are traveling to China once or twice a year to maintain our contacts. In this podcast, we are joined by Michael Tso from the Chinese law firm Chance Bridge in Beijing. We have visited them. We have a lot of common contacts, and we have very cordial relations to Chance Bridge.
Good morning, everyone. And it's really my pleasure today to be here and have these opportunities to discuss with colleagues in Europe.
Michael, great that you join us. We want to give our listeners a brief overview of Chinese investments into Europe, and to understand that we are not talking about a stampede of Chinese investments coming to Europe, because that's what you read in the European press, that Chinese companies are buying everything and gobbling up everything, and we'll all be speaking Chinese in a few years. So what's the reality? How did that develop? And what is the picture from a practitioner who has been advising Chinese investments into cross-border?
Actually, since 2016 until the time period, ending before the COVID-19 pandemic, and the Chinese outbound investment in Europe grew very rapidly. And I think there's a lot of, news and reported transactions that we hear publicly or through other channels. And actually, I noted in 2019, the total investment amount from China into Europe, almost 10.5 billion US dollars. Compared to the 2018, it's increased nearly 60%, and accounting for nearly 8% of the total investment amount by the Chinese investor globally. However, we also noted in 2020, the China's outbound investment in Europe decreased by 45%, and it's only in the amount of 6.5 billion. So it's a huge decrease compared against 2019. And I think the underlying reason, on the one hand, the decrease was mainly caused by the pandemic, because during the 2020, it's very difficult to deal with due diligence by the Chinese buyers. And it's also very difficult to carry out negotiations among the parties. And in particular, it's almost impossible to carry out on-site due diligence. And actually, last year, we helped a Chinese client, very big client. They have potential acquisition transactions in East Europe, but because they cannot be able to carry out on-site due diligence at that time, so the transactions have to be postponed. And we also noted there's a lot of transactions suspended during the pandemic. I think this is the main reason to cause the decrease. But on the other hand, there's also some other reasons. I think the first is that the Chinese investors become more cautious when they carry out outbound investment, because over the past years, many Chinese companies, they already find some outbound acquisitions is not that successful, and they cannot cannot, generate profit for the Chinese buyers. And so generally speaking, the Chinese investors become more cautious to do the investment out of China. And the second reason is that since 2016, the Chinese government has a mandate certain regulations on outbound investment in order to implement more scrutiny on the outbound investment carried out by the Chinese investors.
Just to maybe I can give you an example. It was very funny.
Yeah.
Before 2016, we were asked about vineyards, football clubs, and real estate. And then after 2016, it just stopped. I mean, those were the regulations, weren't they?
Yes, that's what I want to talk about more. And actually, according to these mandated rules or regulations, the Chinese government, set for certain types of the outbound investment. Some they are encouraging outbound investment or outbound project. Some are just restricted and some are prohibited. And as you mentioned, the investment in real estate sector and in entertainment and also in sport clubs and those type of investment fall within the restricted type.
When you say restricted, it is a no-no, or is it something which under certain circumstances would work?
When we see it restricted, because for those kind of outbound investment, the relevant Chinese government authorities may, put more screening and review those projects, and maybe they may refuse to issue the approval to get payment clearance. But for the encouraged outbound investment, and normally it's kind of investment in infrastructure, the energy sector, the advanced technology, this type of outbound investment will be encouraged. And so normally for those type of investment, it may be easier to get approval from the relevant authorities than those types of outbound investment fall within the restricted types.
Just to linger on that, can you lead us through the scenario? I have, this real estate project. It's a hotel on the coast of Albania. Let's just take that hypothetical assumption. It's not a hotel chain. It is just a hotel on the shores of Albania. Does it make sense at all to approach a Chinese company in China? So we are not talking about a Chinese company which has funds outside of China, just a Chinese hotel company. Or is this something we should forget right away because it's a restricted investment, because it's real estate?
Actually, generally speaking, although it's called restricted type project, but it shows certain attitude from the Chinese government authority. So it really depends on the specific transaction. If the target company or target assets is really good, it really have a good business, and it also have a good match with the business conducted by the Chinese buyer, then it's good reason for the Chinese buyers to make the investment. But generally speaking, the investment in the real estate or hotel, even it's just a hotel chain, it's just to hold some trademark, not hold the real estate assets. But generally speaking, the investment in this sector will be subject to very strict review by the Chinese government.
And now, listening to the news, we know that high-tech investments are encouraged, but now there are some restrictions on video games, online games. So online video game companies are off the table now. This is a good assumption that no Chinese company would now actively invest in an online video game company.
Based on my personal experience, I don't think for this type of transaction, as you mentioned, online video, online gaming target or transactions will be much encouraged by the government. And I noticed some very big Chinese companies like Tencent or some other companies still meaning carry out business in China. But as mentioned, it's really depend on the specific case.
Got it. Well, thanks a lot for that insight. I think another thing which people working with Chinese companies need to understand is the difference between Chinese SOEs, private companies, and private equity investors. SOE means socially owned enterprise, and the model of SOEs is actually well known in Eastern Europe, especially in former Yugoslavia, where the concept of socially owned enterprise and publicly owned enterprise actually developed. And until 1989, socially owned enterprises in Serbia were still quite a thing. And for instance, the entire energy companies, there were POEs, which is another form of SOE. And so for us, an SOE is something which we sort of understand because historically we faced that as well. I think the interesting thing about SOEs in former Yugoslavia was that you could not really discern who is the owner. It was the shareholder structure of these companies were very opaque to us. It was just a different concept. But I think the best thing for us, or my personal experience with SOEs in China, was that they are really big, very complex structures. So we, as the China desk of Wolf Thijs, decided not to really approach these SOEs because we have no idea whether we are talking with cleaning staff or the CEO of the SOE. We would not really understand that. For us, it's very difficult to deal with them. PE investors, my personal experience is that it doesn't matter whether they are Chinese or British and private Chinese companies. Those are companies I really enjoy working with because they are owner driven and I really like them. So this is our background on these types. So is this a fair assessment?
Yeah, it's very interesting you mentioned. And in China, under the Chinese law, when we see SOE, actually it means state-owned enterprise.
Okay.
So we call it SOE. And actually, the SOE means the final, or we can say the beneficiary is the Chinese government. And actually, the SOEs themselves are, formulated according to the Chinese company law. And they have board of directors, they have board of supervisions, and they also have trade unions. And actually, it's set up just as companies. But as I mentioned, the beneficiary is the government. But when it's operated and managed as a company. And it's still different from private company because they have to subject to a lot of specific laws and regulations and rules. And those laws and regulations are formulated to regulate this type of enterprise, the SOEs. And also, as you mentioned, there's a lot of large SOEs. And as you may know, some very large SOEs are directly supervised by the government authority. It does not mean it's operated or managed by the government, but it's supervised by the government directly. And we call this type of SOE a central SOE. And other than the central SOE, there are also a lot of local SOE, and it's supervised by the relevant authority at the provincial level. So we call it a local SOE. And all the SOE, they have business in China, and also they carry out outbound investment globally. As I mentioned before, although they are Chinese companies, they are SOE and they have to follow specific laws and rules and regulations. And that's why it's different compared against private companies. When they carry out a specific outbound investment, they need to go through certain, we can call it an approval process, or we can call it a verification process. There's an authority in China, which is a competitive authority, supervising the SOE is called State-Owned Assets Administration Authority. We call it SASAC. So sometimes we call it CSAC. So all the SOE need to be supervised by CSAC, and its outbound investment will be approved by CSAC. In addition, when an SOE to carry out outbound investment, they have to conduct audit and the evaluation activities, and they need to report a result to the CSAC. So there's a lot of compliance requirement or process. It will take much longer time for them to take a decision. As you may appreciate, sometimes the responsible person, or we can say the decision maker of the SOE, they normally will not directly involved in the negotiation process. So the deal team will involve the process, but they have to report to their boss, and then their boss will make decisions. So there's a lot of internal reporting or discussing of process. So compared to the private companies, it will take longer time to deal with Chinese SOE.
That's a very good point, because very often Europeans make the mistake. They say, well, it's government owned, it's state owned. I'm sure they have the political contacts to get the approvals much faster. But that's a complete misconception because in China, it's such a big country and the approval process will take more time and not less time. That's typically a European misconception.
To a certain extent, it is true. When we're only talking about government approving process, maybe it's easier for the SOE to get approval from the relevant authority. They can make the process very smoothly. But on the other hand, there's a lot of internal process, especially when they deal with CSEC. Sometimes for the private companies, when we see the government approval, they need to get approval from certain authorities. But for the SOE, in addition, they need to get approval from the CSEC.
Then a question which always interested me, is it the same for investments in China? They may not have cross-border element, but what I find so frustrating when dealing with SOEs is that you talk to the deal team, then you hear nothing. Then you assume that there are a lot of discussions in the background, and then after several days, they come back to you with a response which may not even fit the question. And it is more or less impossible to go to the next level and talk to the decision maker. Is this the same for you when you are doing deals in China?
In some cases, it's true, and it takes a lot of time to negotiate with the deal team, and sometimes you even maybe reach certain agreement with the deal team. But on the next round or the next meeting, there's something changed because the decision maker have different views. In some cases, it happened, so that's why you have to be very careful to carry out the negotiations with the deal team.
And the deal team, of course, will not sort of lack this enough to say, well, you are aware that we are not the last decision makers. We need to go through certain processes. They will say that once or twice, but then Europeans tend to forget that unless they're constantly reminded. And then they are very often exasperated. Deals which have been worked out get changed afterwards. This is understood from a Chinese perspective that this is the way things are. And Europeans will ignore that because they always think they are talking to the decision makers, or they think deal team will be able to convince the decision makers, which is very often not the case. It's very frustrating for the deal team, I find, sometimes. So I think the recommendation is to have a lot of patience, to have a lot of understanding, and to understand that very often the deal team is actually on your side because they want to do the deal.
I think you are quite right. And if you, especially for foreign parties, when they deal with Chinese SOEs, and they have to understand the structure of the SOE and how to move the deal forward.
That's why we often rely on firms like your firm, because we will never be able, sitting in Europe to have any impact on sort of the internal discussions of an SOE. However, if we are working together with a Chinese firm as a lead counsel, it's much easier for us to understand that and to navigate these waters. Maybe let's move on and let's talk a little bit about private companies. Here, my experience is actually a very good one. Sometimes with private companies, I don't understand their ownership structure because very often you are faced with the owner or somebody who says that he's the owner. Then the decisions are really, really quick. Sometimes you are faced with consultants who claim to know the owner. Then it's a 50-50 chance that the consultant is really well acquainted with the owner or not. And if he's not acquainted, then the entire deal may be not for real, so to say. So this is our experience. So sometimes extremely pleasant, sometimes rather difficult. Is this a good assessment?
I think you are right. Based on my personal experience, in many cases, the Chinese private company will carry out outbound investment by themselves, by their own business team. But in some cases, they carry out investment activities through a consulting company. Sometimes they call it a financial advisor or business advisor. And in that case, you need to be very careful to identify who is the actual owner or actual beneficiary of the private company. Because when you draft documents, or whether you have to submit some report or even to submit merger control filings, you have to know the ownership structure of the private company. Compared to the Chinese SOE, for the Chinese private company, sometimes they will act very quickly and got much less time to make decision to move the deal forward.
Sometimes what we are faced with, and maybe this is just our experience, we have a private company and then we have an individual who is not visibly to us as a consultant. He may or may not have an email address which is consistent with the email address of the company he's working for, but very often it turns out that the guy happened to be a person close to the owner living in Europe. That was the only connection. We had a situation where the work we performed by this sort of like contact man or consultant was then not recognized by the company itself. Does that happen in China as well, or is this cross-border phenomenon?
In that case, you have to be very careful. The worst case may be discuss or negotiate with someone, but actually he is not owner or the beneficiary of the private company. And then the previous discussion will be nothing and cannot accepted by the private company itself. You have to be very careful and you have to know what's the relationship between someone called consultant or agency with the private company. And my suggestion, you dare to directly discuss and negotiate with someone from private company.
And that's not considered extremely impolite to say, can we talk to somebody from the company?
No, you need to be very direct to understand. You can see we want to understand the relationship of the company, whether it's better to involve someone from the private company to involve in the deal process or negotiation process.
Thanks a lot. That's very good advice on that one. We tend to forget that because we very often don't see that the person is actually only a consultant. For us, it's very hard to spot, especially when the email address is the same. But that's a very good advice. Maybe we can once again touch upon capital remittance controls. We are now aware that this is really an issue, but it is always the same question we are asking. Why is it necessary? How long does it take? And is there any way to speed it up? This is always the question which comes from the Europeans.
As you know, in China, the cross-border payment, cross-border settlement are still subject to the foreign exchange administration regulations in China. And the competent authority for the foreign exchange, we call it the State Administration of Foreign Exchange. We call it SIF. So the payment to be made in the outbound investment in China fall within the capital item. So any payment made and the capital items out of China have to be verified by the SIF. Although the verification process is just between the Chinese companies and their banks, but anyway, the banks will be supervised by the SIF. So we still call it you need to get clearance from the SIF. Actually, since the end of 2016, the China implemented very strict control, very strict restriction on payment for outbound investment. At that time, it took much longer time, and you don't know how long you can get the clearance. Although the regulation says 20 working days, but at that time, you can now expect how long you can get the clearance from the SIF. And then in 2017, in 2018, the SIF issued a lot of guidance and new rules to satisfy their requirement on the verification of the outbound investment payment. As mentioned earlier, some other relevant Chinese government authorities also issued some new rules on outbound investment. So it matched each other. And right now, according to the regulation or according to the rule, it still said 20 working days to get verification process, but it's really depend on each case. But over the past 2 years, the SIF clearance process is more clear or more quick than the 2016 and 2017 because the rule is more clear. But anyway, for each transactions, the Chinese buyer need to be well prepared and they need to keep good communication with their banks, with the SIF authority, and also with foreign sellers. And if they can be well prepared, and I think they can move the transaction forward smoothly. But anyway, because the SIF clearance is a legal requirement for the payment out of China, in the transaction agreement, it still have to be a condition precedent.
How could you speed up getting SIF clearance? Is there really a way to do that by just, for instance, requiring the Chinese investor to prepare the entire SIF documentation and already file it prior to signing? Is this a possibility?
For foreign sellers, practically speaking, you have to communicate on regular basis and from time to the Chinese buyers and to ask Chinese buyers to keep you posted of any progress of the Chinese government approval process, especially the safe clearance, because safe clearance is the final clearance to be obtained. So you, the foreign sellers, you'd better to keep communication with the Chinese parties. On the other hand, the transaction agreement, you may put some obligations on the Chinese buyers. Not just say you have to obtain the safe clearance, but the transaction agreement may state that the Chinese buyers need to report to sellers progress of the approval process and safe clearance process regularly. You can put those kind of clauses in the transaction agreement.
I think it's good to have this kind of reporting line so that Chinese buyer is forced to really put energy into the process, really speed up the process. And you see when there's a problem, you can react immediately. In your personal experience, and I know this is completely subjective, have you ever had a case in an encouraged sector and safe approval was just denied?
In terms of encourage type outbound investment, my personal experience is that I don't think for those type of project you cannot get approval. Normally you get approval smoothly. But I mentioned just now, back to the 2016 and 2017, at that time you have to wait. It does not mean you cannot get approval, but you have to wait for a long time. But over the past 2 years, I think in terms of encouraged outbound investment, normally the Chinese buyer will get approval smoothly.
So this is something we can do as well because we have a rough understanding what is an encouraged investment and what not. And it's also upon us, European lawyers, to explain to our clients, look, this is an encouraged investment. It's very unlikely that it will not be approved. It may take time, and that's about it. And it's more a time factor than really a deal breaker factor. Whereas in other fields, which are not encouraged, which may even be restricted, we need to be prepared to have this as a potential deal breaker.
And also, since the last year and also recently, there's a lot of European countries that are continuing to set up the FDI rules or new regulations and try to tighten the FDI screening regime on the national security and public order grounds. So from perspective of Chinese investors, they are more concerned about the filing proving requirement and the FDI regime. And also more recently, Switzerland has planned to set up new FDI rules. So that means that the Chinese investor should expect to encounter more scrutiny by the respective government and face a prolonged approval process. And also, generally speaking, this kind of reviewing process is opaque and compared to merger control filing regime and the security concern associated with FDI are not communicated openly. So there's a lot of concern from Chinese investors. So they became very conscious to carry out outbound investment in Europe.
That's an extremely good point. And I think what we've seen now is that the situation in Europe on FDI is very much comparable to the situation in China 2016. It's something new. The rules are, of course, there, but they are, to a certain degree, very opaque. There is little legal precedent. And so we very much depend on contacting the government in each of our countries, talking to them, and even they will not be able to give us a straightforward answer. So this is a new process, and this is why we in our countries, in some cases, cannot really make a very good prediction whether something will go through or not. And I think that the comparison to China 2016 is a very fair one, because back then, so it was also not clear. And we hope that the governments in our countries will actually issue better guidance and people will get more experience, things will be sped up, and we will be able to clearly communicate to Chinese investors whether this will be a difficult process or whether this will be an easy process. So, Michael, thanks a lot for joining us and for your insights. And to our listeners, we would like to say thanks a lot for listening. We hope that you receive some valuable insights when dealing with Chinese clients. And let us know your thoughts. Give us some feedback. Maybe we can set up a second part of this podcast where we focus more on cultural differences between Chinese clients and European clients, so that we can also, together with Michael, give you a little bit more guidance. And Michael, thanks again for joining us today.
Thank you for joining us for this episode of the Wolf Ties Soundshot. For more information, you can contact us via email at soundshot@wolfties.com or visit our website at www.wolfties.com. You can also follow us here to receive further updates on developments in law and business from one of the leading law firms in Central, Eastern, and Southeastern Europe.